Well, greetings, my beloved clients and friends. Happy New Year. This is our first video of the new year, and we had alluded in previous videos that we wanted to take the first quarter, and when we on all our quarterly reviews, we want to review your beneficiaries. I'm going to tell you a story, and this just happened yesterday. Why this is so important. I had a new client that I had just gotten in like November, and she was a widow, and her husband had died a couple years prior, and they had some assets. They had an account with me. They had a couple properties, and this was his second marriage. It was her first. And he had kids who are obviously grown now, and she had none. Okay. And when we set up the account, we told her, you know what, you need to get a trust set up. And she was kind of in the process, but dragging her feet. And we were trying to get beneficiaries on this account. And she was kind of dragging her feet. Well, Saturday, I received notification that she was not doing well. She had, her health had deteriorated significantly. So, and I knew, and there's a solution that we could do to get beneficiaries on her account that she had been hesitating to do. And so I said, I need to meet with her as soon as possible. We set a meeting on Sunday because I didn't want to wait till Monday. When I got to where she was in like a assisted living, and she was really on hospice. And by the time I got to where she was had lost consciousness. She was highly medicated, and she has days left to live, if that. So unfortunately, she was not in a legal capacity to sign any documentation. And by the looks of it, she's gonna pass without having those affairs in order. So, it's very timely because we had already committed to going through every single client's account and making sure that as far as beneficiaries are concerned, their affairs are in order. So I want to talk to you a little bit about what it takes to get that set up, and it's really pretty simple. And we want to check for what you have and make sure it's what you want, and if not, to get it fixed. And I told Brittany we're probably gonna have a lot of work to do this quarter, but I mean, as this recent story illustrates, this is extremely important. It's valuable that we manage your money, but also prepare for the timely transfer of that wealth when the time comes. So there are basically two types of accounts, and many of you have both. There's either qualified accounts or non-qualified accounts. And what that means is if it's like IRA money, that's called a qualified account. If it came from a 401k, an IRA, a Roth IRA, a company a retirement plan, that type of money, that would be called qualified money. So now it's in some type of IRA with me, IRA. Okay. The other is the non-IRA regular brokerage account, right? Those are basically the two types of accounts. So let me address the IRAs first, and then we'll talk about the non-qualified accounts separate. So on an IRA, you can name a beneficiary, and actually you have to name a beneficiary. Okay, and there's two types. There's the primary beneficiary. That means what happens when you die. And then a contingent beneficiary. That's if you and the beneficiary die at the same time, who's next in line. Okay, and in the state of California, where most of my clients are, it's a community property state. So if you're married, by default, your spouse is your beneficiary. You can name someone other than your spouse, but if you do, your spouse has to give authorization, because that's his or her entitlement by law. Okay, so, and if you name your spouse as beneficiary, you could pass that IRA on, and it's called a stretch, so that they can withdraw from that. They're not required to withdraw from it besides the required minimum distribution. So on an IRA, there's a requirement that when you turn 72 and a half, you have to start taking money out of it because the government wants their tax, because this was untaxed money, right? And so if you pass that on to your spouse beneficiary, they could continue with that, and they don't have to take out any money besides the required distribution. Now, you could also stretch that to the next generation, to your kids. So it could go to your spouse, and they don't have to take out till they're 72 and a half, and it could go to your kids, and they don't have to take any out until they're 72 and a half, and according to that required distribution. So that's a really nice benefit. And if you name someone other than that, including a trust, okay, as your beneficiary, the money needs to be liquidated within 10 years and the tax is paid. So it's not the preferred choice, because it puts you in a situation like, okay, I got to pay taxes. Do I just take it out now? Do I wait till the end of the 10 years, or do I begin and you have to really do some aggressive planning around taxes and how you're going to distribute that if the beneficiary is not named either the spouse or the children. And I had a client who, they came to me because their dad had named the trust as the beneficiary, and it put the kids in a difficult situation because they had that 10-year ticking clock in which they had to get the money out and pay the taxes, right? So a trust is not the ideal way to transfer it if you have a spouse and kids. So, but you could, when you name the beneficiaries, you could name whoever you want, and you could name more than one person. The page that we have has like 8 lines, and if you need more, you could put more. I mean, you could put 10% to this person, 4.5% to this person, 25% to this, and it doesn't have to be a person. It could be an entity. It could be a charity, your church, your university. Whatever charitable intentions you have, you can name it however you want. Okay, but it's important that you do it, because if you don't, then it goes through probate. By naming a beneficiary, it avoids probate. By not naming a beneficiary, it goes through probate. And that's the situation that the estate of this lady that I was talking to likely will end up. And probate, there's 4 negatives to probate. Number 1, it's public. That means everyone knows what's going on. It's public information. Number 2, it's time consuming. It's usually a minimum of 9 months in court that it takes to distribute, to determine how the assets will be distributed. It's costly. Okay, you probably have to get an attorney, and you're going to spend some money to get this estate settled. And it's contestable, right? Meaning other parties could come in and say, well, I'm entitled to some of this, right? And it looks like in the situation of this woman that I discussed, they're going to go through all of that because she didn't have any kids. Her next of kin was a niece who she didn't get along with very well. And the husband, whose money it was initially, and then, he married this lady and they continued to grow that wealth. He does have kids. So that'd probably be who should get it, maybe. But maybe they will and maybe they won't, because it wasn't settled and it's up for the court to decide. So ugly situation, difficult situation that we're about to get into. So yes, if you have an IRA, make sure that we're going to make sure who you have named and make sure that's who you want to be named. Okay. And another thing a lot of people often do is they'll name one kid and they say, well, that kid will give it to his siblings. That doesn't always happen the way you had hoped. So, I mean, just go ahead and name the ones that you actually want to get it, not give it into some person and hope they do what you wanted, right? Well, we've seen that happen before too. So that's on an IRA. Now on a non-IRA or just a regular brokerage account, if you have a living trust and the account is titled in the trust, then it avoids probate. And so whatever the instructions are in the trust, those are the instructions we will follow. That's the best way for a non-IRA. Just name the trust. If you don't have a trust, there's no beneficiaries by default, and it would have to go through probate. And like I said, probate is public, it's contestable, it's time consuming, and it's costly. Okay, so we, by all means, we want to try to avoid that. Okay, and so there's a form called a transfer on death. It's a very simple form that we could do to name. It's not technically called beneficiaries, but it gives us instruction on who to transfer this money to at your death, and that document avoids probate as well. We don't need to have that asset probated because you left written instructions, and that transfer on death form will get those assets to your intended recipients without going through probate. We will just, when we receive the notice of death, we'll just execute your written instructions that we have on file. So I strongly encourage you, and we're going to talk to every single one of you about who your beneficiaries are currently. Make sure that's who you want, and if not, we could change it. And it's really pretty simple. A little bit time consuming, but very simple to get it done right, to avoid serious problems for your loved ones, for us, quite frankly, and for all involved, and just to preserve your estate, make sure it goes to who you want it to go to, and not end up in the hands of someone else, or the government, or the attorneys, or the court system, you know. So be prepared to have that discussion with me this quarter, and Brittany will be coordinating our regular quarterly reviews, but in particular, we're going to be discussing that. Okay, so we look forward to having those conversations with you and setting your mind at ease that these assets at least will be distributed according to your wishes. All right, so hopefully have a great day, and we'll be in touch soon.